Thanks for joining us this afternoon in today's installment of the Pro Bono Partnership of Atlanta's monthly webcast series. Today we'll be talking a little bit about medical records, HIPAA, how it may or may not apply to your nonprofit. But before we talk about this topic, I would like to tell you a little bit about Pro Bono Partnership. The mission of PBPA is to provide free legal assistance to small community-based nonprofits. We do this by matching our clients with volunteer attorneys in the community who work at leading corporations and law firms. A little bit about our client base. All of our clients are 501c3 nonprofits located in or serving the greater Atlanta area. Our clients serve low-income or disadvantaged individuals, and our clients are otherwise unable to afford legal services. If you are interested in applying to be a client or in getting more information about our organization, please visit our website. Also on our website, you'll find a great deal of resources, including articles, past webcasts, and podcasts that specifically talk about the legal concerns of Georgia nonprofits. And now a brief legal disclaimer. Please keep in mind that the advice that Zeke is going to share with you today is just general information. If you have specific questions about your nonprofit, please reach out to your attorney. And now I would like to welcome Zeke Van Kuren, an associate at Southern Health Lawyers and a fantastic and dedicated PBPA attorney. Thank you, Zeke, for joining us.
Thank you. We will just get right into it. For background, I currently work at a boutique healthcare firm, and all we do is healthcare law, representing community health centers and hospitals with a focus on rural Georgia. And so the topics today are going to be broad, but give hope, or ideally will give your nonprofit an idea of when they should be aware of to reach out to Pro Bono Partnership of Atlanta, or other instances where it may raise a red flag and that additional information is needed. And to look into a particular issue. So we're going to discuss HIPAA, then for any of the entities that are dealing with COVID-19 related disclosures, we'll also briefly touch on that. Then substance use disorder records, then look at specific Georgia confidentiality laws and statutes and see how they may apply to your nonprofit organization, and then just go into general records requests and subpoenas and best practices involved when those may be received by your organization. With the presentation and how it's broken up, I'm just going to we'll go over each of the topics. So after the HIPAA introduction, if there's any folks in the audience that have questions, then at that time, I'll answer them, address them to and then go on to the next topic after that. Okay. So HIPAA, it's a word that's thrown around a lot, but a lot of folks don't know what it necessarily means, what's required of HIPAA, and then whether it even is applicable to their organization. So HIPAA stands for the Health Insurance Portability and Accountability Act of 1996, and it's a federal law that established specific standards and requirements for transmitting health information. So it regulates the privacy of that health information, security of health information, and then notification of breaches of confidentiality. In terms of the HIPAA world, the folks that are in charge of regulating it and promulgating the rules, that's Department of Health and Human Services, and then actual enforcement is through OCR, which is a branch of HHS. Okay. So another buzzword that's associated with HIPAA uh, is PHI. And so just broad strokes to start off with, PHI is any oral, electronic, or paper record that is created or received by covered entities and business associates that contains any identifiable information and any health information. So think about a patient's name, a prescription information, date of birth, medical condition, uh, phone number, medical diagnosis. What you're looking for PHI is any sort of personally identifiable information that could be used to tie back um, to identify a specific individual if a third party was given that information. Um, but because it's 2020, a lot of PHI isn't necessarily in a paper format any longer. And so if I say PHI or EPHI, just know that it's referring to the same general concept where PHI, if it's electronic, is just known as EPHI. Um, and most likely that's how a lot of the health records are transmitted just in 2020, depending on a specific entity. Okay, so we have PHI, and so HIPAA, federal law that governs your personally identifiable health information. And then if you look at the definition of PHI, it says if it was created or received by covered entities and business associates. Okay, so what kind of information is covered and protected by HIPAA? So any sort of written documentation, all paper records, spoken and verbal information, including voicemails, um, anything stored on a smartphone, memory card, USB, video recordings. It's pretty broad. Where anything that has that identifiable information um, that can be stored in a specific format, whether it's hard or electronic, is going to be subject to HIPAA. Okay. So we have, like I was saying, for the big broad structure though of HIPAA, where for our purposes, we're going to deal with the portions that look at protecting privacy and the security of the health data. And so for the applicability of HIPAA, um, it applies to covered entities and business associates. And so covered entities are, so Uh, with covered entities and business associates, I think the thing that just needs to be stressed to folks is that just because an entity may interact or deal with uh, personally identifiable information, that does not automatically constitute that they will be a covered entity or business associate for purposes of HIPAA. So for the covered entities, those are the three big ones. There's health plans. So think about any sort of third-party payer, Medicare, Medicaid, HMO. Those would constitute a health plan. Then you have healthcare clearinghouses, which are entities that reformat the PHI in a specific format. And then it's also healthcare providers. Okay. Sorry, I was just reading the chat function where it looks as if there's some audio problems, but we will continue on. Um, for nonprofit organizations, they don't qualify as a health plan, so that first one can be eliminated, and then they also aren't going to constitute um, healthcare clearinghouses. And so that second qualification to be a covered entity is also eliminated. So the only time a covered entity would be, or the only time a nonprofit organization would be a covered entity for purposes of HIPAA is if it qualifies as a healthcare provider. Okay. In order to be a healthcare provider for HIPAA, the healthcare or the entity must furnish, bill, or receive payment for healthcare in the normal course of business. And so this is the big one. And they transmit the covered transactions. So the way HIPAA defines covered transactions are claims, benefit eligibility inquiries, referral authorizations, um, a couple, just anything to get payment for services rendered is probably the broadest way to describe covered transactions. So just because you provide healthcare services, again, doesn't mean that you're subject to HIPAA, where you need to also receive payment for those services and then transmit that electronically. Okay. And so this is just a quick and dirty way to think about whether you're subject to the HIPAA requirements and all the fun things that come along with that. So in order, any sort of nonprofit organization should ask themselves just two questions. Does my organization furnish, bill, or receive payment for healthcare services on a patient encounter claims basis? And so just what that means is when are you receiving any sort of payment for an interaction that you're having with a client or for specific services that were provided to an individual that the nonprofit is serving? If uh, no payment is received by the nonprofit, then the nonprofit is not a covered entity. But if there is some sort of payment received, then you'll go to the second question, and that's whether the nonprofit transmits any transaction electronically, where you're sending out a request for payment to a healthcare insurer, some third party payer to receive payment for the services that were rendered to an individual. Because of the nature of the nonprofit organizations that Pro Bono Partnership of Illinois works with, there aren't going to be many folks in the audience today that actually qualify as covered entities under HIPAA. So let's go to a couple examples. So a healthcare provider contracts with a billing service that submits claims information electronically on behalf of the healthcare provider. So this is a healthcare, or this would be constitute a covered entity that would have to comply with all, the rules and regulations of HIPAA. So you have a healthcare provider, they're providing healthcare services, and then those services, uh, they're receiving payment for the services, and then payment inquiries being done electronically through the billing service. Okay, and then the next one. Uh, again, a healthcare provider that transmits identifiable information electronically to Medicare, Medicaid, or an insurance company in order to receive payment reimbursement for care rendered to a patient. So care has been rendered to a patient, and then payment is being received for that care, and then the information to identify payment as being sent electronically to whether it's Medicare, Medicaid, insurance company. Um, it doesn't matter. It's being sent electronically to a third party to receive that payment. And so again, that transaction and that entity will qualify as a covered entity under HIPAA and will have to comply with the rules and regulations of HIPAA. Okay. And this is more in line to what folks are applicable to folks in the audience is if a health clinic provides free services to patients and it doesn't seek reimbursement for those services, for the medical services from Medicare, Medicaid, or third party payer, um, are they a covered entity? So, like, the health clinic's clearly providing healthcare services, but there's no payment that's being received for those services. And so because there's no payment received for those services, then they do not qualify as a covered entity. And then if you wanted to go even a step further, because nothing is being sent electronically with that identifiable information, that's just a second confirmation that the health clinic providing free services, again, is not a covered entity for HIPAA purposes. A camp collects health information on its websites or emails from campers and their parents, just to have general information in case anything pops up while a camper is in the care of, while the camper is in their care. So is the camp a covered entity? Again, there's not any payment being or received for any healthcare services being rendered. This is background information that's being collected by the camp in order to best serve the folks that are attending it. And so a lot of these inquiries for whether a specific organization is going to be required to comply with HIPAA's rules and regulations are very fact specific to the nonprofit organization. And the OCR, which is the enforcement agency of HHS that oversees HIPAA enforcement, has published a great tool for folks to either verify that they're a covered entity under HIPAA or to go through the flow chart and get confirmation that they're not a covered entity for HIPAA purposes. And so that link is on this slide for folks to go through. Again, just because it is fairly fact specific depending on the organization. Okay. So we'll also briefly touch on business association or business associates. HIPAA regulations also apply to business associates of covered entities. A business associate is an individual or entity that performs on behalf of the covered entity a function, activity involving the disclosure of PHI is not a member of the covered entity's workforce. So common examples of business associates include companies that do claims processing, medical, think about medical billing companies, health information exchanges, data conversion, shredding companies is another one, medical transcription companies are also fairly common where if folks are transcribing things and they record it, the transcription company will do it if the provider doesn't have enough time. What is a common thing that nonprofit organizations should be aware of is a lot of folks have a habit of making any entity or anybody that they partner with execute a business associate agreement, even though that it may not be appropriate, or it's a CYA for the covered entity. So if you're asked to execute a business associates agreement, um, just reach out to Pro Bono Partnership of Atlanta to see if it's needed, because for a lot of if you get into the technical requirements for HIPAA, most of the time for say or for the purpose of nonprofit organizations, a BAA or business associate agreement isn't going to be applicable when a nonprofit partners with um, a covered entity. Okay, so we have what is a covered entity under HIPAA? Um, and so even if your nonprofit
Zeke, we have a
organization
couple
is
of
not
questions
a covered,
that are related to HIPAA coverage. So I was wondering if this would be an okay time to cover those. Our first one
yep,
is related to the BAA, and
yep.
I think you might have already answered this. Should a nonprofit have a BAA with a healthcare provider if the nonprofit is referring their clients for care and providing coordination services, post-care? The nonprofit may make nominal payment to the provider for services.
Most like, or
It
is
is.
this in the chat box?
Or this would this be one of those scenarios where it's very fact specific, so you should reach out to your attorney, your PVPA attorney.
I mean, off the cusp, I would say no, because you're not trying, or the covered entity isn't providing access to any PHI of the individual with that referral. Because if you think about that, under that scenario, anytime a provider makes a referral to another provider, then the assumption would be a BAA is warranted. But it's when a covered entity, when a BAA is only appropriate when an entity is doing a service on behalf of the covered entity. So if you're making a referral to another provider, you're not doing a service on that other provider's behalf. Um, but I think it would be helpful just to get a little bit more background information to confirm one way or another. But by and large, a referral to another entity doesn't
Okay.
require BAA be in place.
And if a nonprofit is just collecting premiums, does that make them a covered entity?
What do you mean by premiums?
That's
Like,
all that is in the question. So Patrice, if you would like to provide a little more clarification on what premiums mean,
okay.
or this might be a situation where it's not clear cut and they can reach out to us directly. I'll go on to the next question. If you're a nonprofit organization receiving federal funding, for example, housing, utility, and medical assistance, are you required to follow HIPAA standards? And they do refer individuals to other medical agencies.
So I think in that question, it would be helpful to know whether that organization is providing any sort of healthcare services to the individuals that they're assisting with. Because just again, a lot of folks receive federal funding, but that HIPAA won't come into place, isn't in play unless you're one of those three types of covered entities. So they're not a healthcare clearinghouse, they're not a healthcare insurer, and then they would only qualify as a healthcare provider. And making a referral to or a referral or to services in a community isn't, unless they're actually providing services to that individual, then it doesn't sound like they are.
Okay.
Then HIPAA
And they
wouldn't
just
be
responded
applicable
that they
to
only
them.
provide referrals.
So again, there's no actual care rendered to their client base. And so that's what we care about in order to qualify as a healthcare
Okay.
provider for HIPAA purposes.
And then we have lots of questions here. We'll cover a few more before moving forward, just to be cognizant of time. If we have a nonprofit and they bill crime victims comp for sexual assault exams, is the nonprofit subject to HIPAA?
What are they
They
doing?
said they bill crime victims comp.
Hmm. I'm assuming that has some sort of, is that a forensic interview, I guess,
It's a forensic
after?
interview.
I don't know. Um, I would have to look at how they're being, how it's billed, and who's the payer. Where if it's a state, if it's done electronically, might again off the cusp, I would say that they would be subject to HIPAA. Um, Sexual assault, there is, uh, it, yeah. I mean, again, I think it would help to have a little bit more background, but just my initial
And once
answer would
again, it
be
sounds
yes for
like,
them.
as you mentioned before, these are all very fact-specific inquiries, so they have to be looked at closely.
Yeah. So that chart that the OCR published, um, and that link, it's a very detailed flow chart that folks are going to be able to go through to see, yes, no, yes, no. Um, and at the end of it, to just have a little bit more guidance because,
Yeah.
there is a lot of gray.
And I'll go back to the question about premiums. Does collecting premiums make you a covered entity? And she clarified that by premium, she just means collecting payments under medical plans.
So yeah, they're receiving payment for care rendered. Um, and I'm assuming, I mean, again, 2020, I would assume it's being done electronically in some format. And so HIPAA would be covered, or HIPAA would be
And we do
triggered.
have a few more questions, but in the interest of time, I think we should go ahead with the rest of the presentation. And if time allows, we'll come back and cover those at the end.
Okie doke. Again, I'm also happy to just like follow up at the end with specific individuals and answer their questions via email afterwards. Okay. And so if an entity is not a HIPAA covered entity, or sorry, if an organization is not considered a covered entity under HIPAA, then the question is, what are their obligations? And then any sort of nonprofit in that sort of scenario should be asking themselves about not only best practices, but what their duty is to the client base that they serve. And so just best practice would be that a nonprofit that isn't a covered entity for purposes of HIPAA safeguard any identifiable health information it has. This recommendation is done for several purposes. First, the nonprofit organization or the healthcare providers that they may partner with may be required to protect that information by Georgia statute, where there's specific rules related to types of uh, medical records that have higher degrees of confidentiality protections compared to other medical records. Um, The second big consideration is that complying with the HIPAA principles, such as limitation on the uses and disclosures of PHI, will just meet your client base's expectations of how the private or how their PHI is being handled by your organization. where nobody, when any sort of health in a healthcare transaction, the patient, client, whatever you want to label them, has the assumption that that information is being given in some sort of privacy, whether that expectation is made explicit because of HIPAA requirements, or it's just an innate understanding with the individual specifically. And then the last one is that if a nonprofit doesn't safeguard PHI, then you lose the trust of your clients and patients, which doesn't benefit the mission of the organization. Okay, we will go through this pretty quickly for COVID-19. Um, so if HIPAA is applicable to your nonprofit, just big picture, generally covered entities uh, are prohibited from disclosing PHI to a third party without a patient's authorization unless a HIPAA exception is met. And so, with the COVID-19 pandemic that's ongoing, HHS has identified several exceptions that would allow a covered entity to disclose a patient's COVID-19 status to a third party. And so, the big one is patient authorization, which is very straightforward for any sort of uh, medical record authorization, where it's the gold standard. If the patient or client authorizes the disclosure, then you're everything's on the up and up. Then the other exceptions that HHS identified are disclosures to prevent a serious and imminent threat or public health reporting activities. And so public health reporting activities is going to be the one most applicable for nonprofit organizations, um, where that just means that it's permissible to let your local public health agency or county health agency know if you've had a patient test positive for COVID-19. Um, and then the extent of your reporting obligations will be fulfilled at that point, where once the local health department has been notified by the nonprofit organization, um, it's up to them to notify the patient's employers and other potential individuals that may be impacted. So the purpose of this guidance by HHS that came out in April, it's crazy to think about, all this has been going on for that long, is just to assist providers and organizations with contact tracing, where they may be worried about reaching out to folks, asking them to be tested for COVID based on the test results that are positive test results of one of their patients. Um, if HIPAA is applicable to your nonprofit organization, just because of the COVID-19 pandemic. The other thing that HHS stressed in their guidance is any sort of public health reporting activities, the covered entity needs to make a reasonable effort to limit the information to the minimum necessary to accomplish the purpose. So what that just means in plain English is if you're reporting that a patient tested positive for COVID-19 to the local health department, you're also not reporting to the local health department that that patient is morbidly obese and has a high cholesterol. The only information that is being reported is for the infectious control issue that the local health agency is addressing, i.e. the COVID-19 diagnosis. And anything else in the patient's medical record or background isn't relevant and is not being shared with when that information is reported to the public health agency. Okay. Okay. So Do you want to stop for COVID-19 questions
We
or
don't have
keep
any
going?
COVID-19 questions right now, so we can keep going.
Okay. So, just again, a lot of nonprofit organizations aren't will not be considered a covered entity for purposes of HIPAA. Uh, However, that doesn't mean that there aren't other sand pits almost to be aware of with certain types of records that a nonprofit organization may be dealing with. And so one of those is substance use disorder records. And those are any sort of records and information identifying an individual as having a substance use, are considered confidential and cannot be disclosed without the written consent of the individual or a person authorized to give consent, and then certain exceptions and exclusions described in a federal statute that we'll talk about on the next slide. Um, and so the big thing with any sort of substance use disorder uh, records is that it requires a subpoena plus a court order authorizing the actual disclosure, which is a pretty high threshold to meet. Just where in the eyes of the law, they don't want individuals seeking um, to be to be stigmatized for substance use or any sort of treatment associated with that. Okay, so the exceptions that permit the disclosure of substance use disorder records are to the following: to medical personnel to meet some sort of medical emergency, um, to law enforcement officials to report a crime or some sort of imminent threat of crime. Um, Again, it's pretty high bar where you, if you have substance use disorders, imminent threat doesn't mean something that may occur in a month. It needs to be, you know, almost immediately in order to permit that sort of disclosure without the patient's consent. Um, Another exception is when you're reporting allegations or good faith belief of child abuse and or neglect. Um, and then going back to kind of mirroring the first one is a court order for good cause. And the way that it's just defined by the law is good cause is it's necessary to avert a substantial risk of death or bodily harm. So think about imminent threat of a crime to avert bodily harm to either the individual or third party or a medical emergency to avert that harm. Um, where the big takeaway for any sort of substance use records is that disclosure, whether it's being done for treatment, payment, any sort of healthcare operations, will always, always, always require the individual who's undergoing that treatment to consent to it. And then just there's a wonky caveat where for HIPAA, consent can be done orally and documented in a medical record, but for any sort of substance use disorder record disclosure, then the consent must be documented um, in writing in order to be considered valid. Okay, and now we are going to turn to Georgia-specific confidentiality laws. And so these will deal with mental health and developmental disability records. And these are the types of records that, in the eyes of the law, just receive extra protections, where, again, even if you're not a covered entity for HIPAA purposes, then you still have obligations to ensure the confidentiality and privacy of select or certain types of records that your organization may handle. So for mental health and developmental records, that constitutes all information about individuals, whether it's oral or written, and regardless of whatever the form of the records may be. Um, and it's the only permitted disclosure for mental health and developmental disability records are when the individual that those records relate to gives consent, or when Georgia statute specifically authorizes the disclosure. So we'll discuss the specific instances of disclosure for mental health and developmental disability records on the next slide. Okay. And so examples of when the statute authorizes disclosure of mental health and developmental disability records is that disclosure is acceptable when it's made to physicians or other healthcare providers, psychologists for the continuity of care for that individual. Again, mirroring the substance use disorder records, disclosure is also permitted in the case of a bona fide medical emergency where the law doesn't want an individual who has a medical emergency not to receive appropriate treatment based on that their record or that certain records weren't disclosed to a treating provider during that emergency. Disclosure is also permitted to the guardian or healthcare agent of an individual or to the parent or legal custodian of a minor. If an individual authorizes it, disclosure is also permitted to that individual's attorney. And the last one is disclosure in response to a valid subpoena or order of a court of competent jurisdiction. And towards the end of this presentation, we will just touch on what a valid subpoena looks like and go into that in a little bit more detail. So with Georgia confidentiality laws, you also need, or nonprofit organizations should also be cognizant of privileged communications made between a mental health professional and their clients that are being served. And so individuals that are covered by this privilege, psychiatrists, psychologists, licensed clinical social workers, a nurse specialist, in a psychiatric mental health setting, goodness, behavioral nurse practitioner. There's the clinical nurse specialist has a couple different names, so you may see them referred to as APRN or just a general nurse practitioner, but it has to be in a psychiatric mental health setting. Other types of practitioners are licensed marriage and family therapist, and then also the last one is a professional counselor. And the thing that needs to be just stressed for this is mental health professionals have an affirmative duty to assert a privilege on behalf of a client, and they don't have the right to waive the privilege without a patient's consent. And so what all that means, again, in plain English, is in Georgia, the only if you have a communication with a mental health professional, then that communication is considered privileged and cannot be disclosed. The only person who has the right to waive that privilege is not the mental health professional. The privilege lies exclusively with the patient or client that made that disclosure to the mental health professional. Okay. So you have those certain types of records that the state thinks or has identified need special protections, the mental health and developmental disability records. But you also have these privileged communications that have been identified. And so nonprofits need to be aware of the intersection between those two expectations, where although mental health and developmental disability records are authorized to be disclosed in certain situations, that disclosure of those records does not also permit the disclosure of privileged communications or any sort of records containing privileged materials with a mental health professional, where you're able to you're able to disclose mental health and developmental records in X, Y, and Z situation if met, but that doesn't negate the privilege that comes with those types of records. And any privileged communications or records that have that the privileged materials should not be included in the disclosure for those types of records. Something that is important is that for any sort of privileged materials, the only way to really get around it is with the express signed order of a judge. We'll get into that in a couple slides, what that looks like, or the written authorization of the patient. But privileged communications, rule of thumb is disclosure should for those types of records is never permitted, except if authorized by the person who was making the communication. Okay.
And Zeke, we do have a question
Okay.
about, I guess, non-HIPAA related general records question, it looks like. How long after the last visit does the nonprofit have to hold on to a chart for the medical records? Nice.
10 years.
Good.
It doesn't have to, Georgia statute doesn't require that the record, Georgia requires that the statute or that records be retained for 10 years, but the physical record doesn't necessarily need to be retained for that period. Where if the record is scanned or uploaded electronically, and that file is retained for 10 years, and that's permissible. So you don't have to hang on to the physical file for 10 years by any means, as long as there's some record of the file that's accessible.
Okay. For now, it looks like that's the only question. Oh, what about for a minor? Is it the same?
I can double check, but I think it's still 10 years after the last visit, where I don't see any reason that it would change because it's a minor or not. It's the last date that care was rendered, but that's easy enough, and we can double check and follow up with that organization specifically.
Okay. And one other question, I think this was covered. If a person leaves a facility where they have been for over 30 days, how long do you have to hold on to their records? Is it still 10 years?
It doesn't yet, correct, where that records for the care that was rendered, it's that 10-year window of retainment. And looks like the member may be asking whether they have to retain the physical or records for that whole period. But as long as the complete record is accessible in an electronic format, then they don't have to maintain the physical record, I guess, once the person has left the facility.
And does the 10 years apply for deceased individuals as well?
Yep. It's I'm just thinking, we have a couple of clients that they literally like rent out warehouses of medical, like just to store medical records. Um, and it's just the nature of doing or working with any sort of health records for Georgia in pretty much any state. That's not an unusual
Thank
requirement.
you.
Okay, so going to records requests and subpoenas. So I just wanted to give like a cursory overview of when your organization may receive a records request or a subpoena and how to respond to those types of documents. And so let's just go break down a subpoena. A subpoena is for an actual individual or organization to attend a trial or deposition or other proceeding. Most likely, your organization is not actually being served with a subpoena. They're being served with something that's called a subpoena ducis tecum, which just means that the person issuing the subpoena wants specific documents that they believe your organization has um, in their possession. And so just turning to who can issue subpoenas, judge or magistrate judge, a prosecutor, lawyer, or administrative officer. The thing that is important is just to, uh, whenever a records request subpoena is received, is to identify who's being or who issued the request, and then the response, and then make the response accordingly based on who issued it. Okay, so if a subpoena is signed by a judge or a magistrate, it's permissible for an organization to disclose identifiable health information per the subpoena signed by the judge or magistrate. Um, the reason that is those individuals are considered impartial, independent officers, um, and essentially are the law. But it's very, 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 very uncommon to actually receive a subpoena or a records request that's signed by a judge or a magistrate. Um, so going to the next slide. Uh, Most of the time, so this gets into where most of the subpoenas are going to be coming from. Most of the times they're coming from other attorneys that are issuing a subpoena. I can issue a subpoena requesting the records or the health records of um, Bill Gates and sign Zeke Van Kuren at the bottom of it. But that doesn't mean just because I issued a subpoena that Bill Gates has to provide his health records to me. Um, so if you receive a subpoena or records request that's not signed by a judicial officer and it's signed by an attorney. So it's just some things that folks should look out for. See if the subpoena is appropriate or has jurisdiction. So, sometimes you'll get something from out of state. If it's an out of state subpoena, um, then by and large, it doesn't have jurisdiction unless it's issued by a federal court. Um, but we'll go into a rabbit hole where if there's any sort of subpoena that's ever received by a federal court, the nonprofit organization, just best practice would always be to reach out to Pro Bono Partnership of Atlanta for review to ensure our appropriate next steps are had. Um, and then going back to uh, a subpoena not signed by a judge or magistrate, the nonprofit should attempt to receive some sort of satisfactory assurances that the individual has been notified of the subpoena, given the opportunity to object, um, and the time periods either elapsed or the objections were denied, that a qualified protective order be put in place, and all that means is that the nonprofit organization will release the requested information, but the qualified protective order will ensure that that information is kept confidentiality or kept confidential between the parties to specific litigation or legal dispute that's ongoing and not made publicly available. Um, and then the last one is just reasonable efforts to the individual um, that the request pertains to either obtain their consent um, for their disclosure of the identifiable health information. Okay. So this is just a checklist of things for folks to go through. Does it require disclosure of identifiable information? If so, red flag, and you should just look at that type of request much more closely. Does the court that issued it have jurisdiction? Going back to what we discussed a couple minutes ago, if it's a state court that is located outside of Georgia, then then your organization has no obligation to comply with it. If it's a federal court that issued the order or subpoena, then additional follow-ups needed with some sort of legal counsel. Look at who signed it. A lot of subpoenas or records requests will look very formal and official, but 98% of them come from attorneys and not judges and magistrates. Um, if it's a judge or magistrate, then comply with the order or records or subpoena. If not, then review carefully and respond appropriately. Um, and then the last little tidbit is just in going back to, I think, what was discussed earlier, is any sort of disclosure of identifiable information should always be limited um, to the greatest extent possible. Where if the subpoena requests my medical records for the past um, 2 years, and the organization has those records for my medical records for the past 4 years, um, then 4 years of medical records shouldn't be produced to the requesting party. Only the 2 years laid out in the order or the subpoena should be produced. So you just need to be very cognizant of identifying what's being requested and, if appropriate, only producing the requested information and nothing else. Okay.
I'd like to go back. There were a couple of HIPAA related questions that we didn't get to, and want to try to address those real quick. One of them is regarding a nonprofit that's a job placement agency, and they work with individuals with disabilities. They get referrals from an organization that's not under Medicaid, and then another agency called Persons with Disabilities, which is funded by Medicaid. In this situation, is the nonprofit required to follow HIPAA standards when they're only providing job placement services?
No, they're not providing any healthcare services to an individual to therefore they couldn't be like a healthcare provider.
And then another client asks if they're a nonprofit and they hire an independent contractor who's a social worker who leads a support group for individuals with cancer. If our nonprofit wants to get the names of the individuals in that support group, can they? The contractor is claiming that under HIPAA that she can't provide those names or contact information of those individuals without a HIPAA waiver signed. And no payment is collected.
Well, I guess it sounds like the support group, is it not, is it being
It
done
looks like
through
it's
the
associated with
nonprofit?
the nonprofit and it's led by the independent contractor.
Or I would assume that in that instance, then the nonprofit would have the contact information for the folks as they register for the support group. Again, it would be helpful to know how that works, like the nitty gritty, because the social worker does have a point where if it's her support group that she's leading, then that disclosure wouldn't be permitted um, under HIPAA. But I'm not a little bit like 5 minutes on the phone would be like helpful.
Okay, and she responded also that it looks like they are not covered by HIPAA, but they would be covered by Georgia law, and that they would be required to safeguard the identifiable information. So they would need to have would they have to have some sort of release signed by the individuals for the independent contractor to share their contact information with the nonprofit?
So I guess again, I'm having trouble picturing. Um, so if it's a nonprofit and they are putting on a support group, then that support group, the registration should be going through the nonprofit, not the social worker. And so the fact that he or she has that information is just a little messy to me, where it could just be like a structural issue more than
Okay.
a privacy question, to be honest,
Yeah,
if I'm being
sense.
honest.
Those are all the questions that we have right now, Zeke. Thanks so much for sharing your expertise with us and all of this great information. We really appreciate it.
And then is this chat going to be up for a little bit after the presentation to go so I can review and just email you
Yeah, we can keep it open.
or follow-up answers to specific individuals?
Thank you.
Okay, that's great. If that works then I'll take a look at that later and just email you my
if we have their
responses and
contact information, then we'll make sure we get that to them. Thank you. And thanks to our audience for joining us today.
Okie doke. No problem.